Right, hi folks. It's very good to be here. I've been here for a few days. I started off by doing the chip hack. I figured that since I was helping to write licenses that involved FPGA code, it might actually be sort of reasonably helpful to figure out what NRF1 is. So after a couple of days of doing that, which was absolutely fantastic, I can now make LEDs flash on and off with the best of them. So my name's Andrew Katz. I'm a lawyer. I'm a partner at a firm called Moorcrofts, and we're a small boutique firm. We do mainly technology work. I'm the head of the technology team, and I've been involved with the free and open source software world for many years. And more recently, I've started getting involved in other opens, such as open hardware, open data, and so on. Part of that process got me involved with CERN, and I helped do the drafting on the CERN Open Hardware License version 1.2. So just to recap where we are at the moment. The rationale for the CERN Open Hardware License is that it provides copyleft for hardware. Copyleft for hardware is quite a tricky thing to do. If you want to have a permissive academic style license for hardware, that's pretty straightforward. People have been talking about using licenses like BSD, and last time I was here I was talking about the solder pad license, which is a license that I hacked together. Basically, it's very, very similar to the Apache software license version 2.0, which is a permissive license. That's a pretty straightforward thing to do. But if you're looking to implement some form of copyleft, that makes life a lot more difficult in hardware than it is for software. So the rationale behind the CERN Open Hardware License is very similar to the rationale behind the GNU GPL, in that CERN wants to promote a commons of freely available and freely reusable hardware designs. And the way that it works is around the design documentation. So if you modify or extend any design documentation that you obtain that's been released under that license, and then you release hardware based on that design documentation, you're under an obligation to make your modifications to that design documentation publicly available under the same license. So people are saying, there we go. Why not? Why can't we use GPL version 3 for hardware? Doesn't that do the same thing? And indeed, if you read GPL version 3, it does mention some items of hardware in there, like semiconductor masks. And to a degree, it does work. It works best for the sorts of hardware that are most similar to software. So sort of digital designs, then it sort of can work to a degree. But there needs to be a clear distinction between the source forms and the object forms. What the main problem that you have when you're trying to apply some sort of license to hardware is that the IP is a lot more messy. With software, it's pretty straightforward. You're talking about copyright and to a degree patents. But copyright law is pretty much harmonized throughout the world. It's reasonably predictable what's going to happen from jurisdiction to jurisdiction. But most crucially, whatever you're doing with software means that there's constantly going to be some sort of copying going on. If you're downloading it, if you're running it, if you're modifying it, if you're compiling it, if you're distributing it, all of those things are things that are affected by copyright. And every time you're doing something that's affected by copyright, you have the ability to be able to apply a license to it. And if you're applying a license, you can apply conditions, and that's how you can make the whole concept of copyleft work as far as the software is concerned. With hardware, that's more difficult. The IP situation is much messier, and it's not always the case when you're transferring a piece of hardware from somebody to somebody else that necessarily there is some form of intellectual property that's involved there that you can attach a license to, and I'll talk about that in slightly greater depth. So just summarizing, hardware is a lot more complex from an IP perspective than software. Part of the issue is also that the range of hardware itself is much, much broader. And the first open hardware project that I became involved with was one that actually involved a hydrogen-powered car, so mechanical devices. Then I became involved in a project that dealt with an autonomous drone, so that involved some mechanical devices plus some software involved as well. Then I became involved with CERN, which at the time was looking at open hardware licensing as it related to circuit boards and sort of reasonably high-level circuitry. So the idea is that when we've been looking at this licensing, we've really tried to cover the sort of broadest range of hardware possible, any physical object that you can imagine, all the way from decorative items like statues, mechanical devices, suspension components for cars, and there's even some open source beer available. A whole range of items. And then we get into the more interesting areas when we delve down into electronics, into the components, and then we're looking at items like FPGAs. And is that a hardware device or is that a software device? And it's something that the law finds very difficult to cope with. So that's really what we've been looking at more recently. But version 1.2 was really sort of centered on looking at hardware in terms of electronic circuitry before we get into the details of things like FPGAs. So the way that it works is by using the documentation as the key to the license. So the documentation, if you're thinking about it in software terms, is basically the source code. It's the design documentation. It's everything that you need to create the design. So it could be blueprints. It could be bills of materials. If you're talking about circuitry, it could be the track layouts for circuit boards, so on. It could be really anything that you need in order to create the final hardware design. And the key difference between the way that the CERN OHL and open source software licenses like the GPL work is the fact that the documentation should always be publicly available. And this is something that people don't necessarily appreciate. If you look at the GPL family of licenses, even though if you transfer a covered work to somebody else, and you have to make that, you have to give somebody else the opportunity to get hold of the source code, or you have to provide the source code to them, there's no obligation to make it publicly available. For somebody else who receives it is perfectly entitled to make it publicly available if they want to. But there's no actual obligation to make it publicly available. So it's perfectly possible within the GPL world for a piece of software never to be made available to the public. It can keep on sort of flowing down from one individual to the next, and if they choose not to make it public, then that's absolutely fine. That's not the way that the CERN OHL works. There is this idea that once you've modified the design documentation, and as soon as any hardware item is released to the public, you have to make the design documentation available generally to the public as well. So we had a few concerns about version 1.2. The first is that it's currently incompatible with other commonly used licenses like GPL v3, like the TAPR OHL. So that means that it's quite difficult to take two projects that are licensed under CERN OHL and, for example, GPL v3 and to combine them. If you do that, then you've got an incompatible product and you're not able to release it to the public because you can't comply with both licenses simultaneously. That's not possible. So we've tried to address that point. The scope of the copyleft is sometimes a bit unclear under version 1.2, so we've tried to address that as well. It's got some slightly unfortunate gendered language in it at the moment, so we've removed that. It doesn't work too well for designs that have digital intermediate forms. So if you're looking at any sort of design that you're feeding through a tool chain, in between, as it comes out of one tool and gets fed into the next one, there'll be some form of intermediate form there. And it wasn't clear how that was dealt with from a licensing perspective, so we've cleared that up as well. We've just generally tidied up the language. But what we really want to do is to avoid license proliferation. And if you're familiar with the world of free and open source software, you'll realize that there are hundreds of licenses out there, a subset of which have been approved by the OSI or the Free Software Foundation. And it creates a lot of work for lawyers, which is great for me, but it's not very helpful when you're trying to produce product that incorporates a whole bunch of bits of code under these different licenses. It's not too much of a problem when they're academic licenses, because you can merge academic licenses pretty easily, and it's not too much of a problem if there was only one copyleft license, because you can merge the academic licenses into the copyleft license. But unfortunately, there are plenty of competing copyleft licenses out there, and they tend to be incompatible with each other, and there's a number of sort of bodges that have been created to try to improve compatibility. We're in a happy situation in the world of open hardware where license proliferation hasn't happened. So what we want to do is really try to make sure that the CERN OHL is a license, or as you'll see, a sort of family of licenses, which really provides for all of the major use cases. So you don't have to go outside that family to use a different license. Every time you get licensing compatibility, that basically means that you have individual silos of projects that can't be combined. That's a bad thing. So if we can reduce license proliferation, then obviously that is good. So there have been a few inspirations for the improvement. GPL version 3 uses the word convey instead of distribute, because distribute has technical meaning in different jurisdictions, and it just tends to make it a bit more international, so we followed a similar process there. Julius did some great work on modifying the Mozilla Public license, and he had some interesting concepts in there. So we've sort of borrowed or possibly stolen one of those, which is the sort of concept of an intermediate form that I mentioned briefly earlier. A guy called Eli Greenbaum in Israel has been working on some open hardware licensing, and he's had some quite interesting commentary about the way that you can ensure that attributions are kept persistent and actually marked on a specific product, so you can easily go back and anyone who receives the product is able to, for example, look at the marking on the product. It may be a short form URL, go and have a look at the URL, which will lead you to the design documentation. Tapper Open Hardware License has got some interesting patent clauses in there. We borrowed some of aspects from that. And then Apache 2.0 has got some pretty industry standard patent clauses and also the provision relating to notice.txt. So we borrowed similar concept for version 2 of the CERN Open Hardware License. So that's a list of the specific improvements. I'll just go through them in a little bit more detail. So I mentioned we removed the gendered language. We've used this concept of convey instead of distribute. We've put a word instantiate in there, which really is designed to cover any circumstances in which a physical object is created. We just ended up with the sort of word salad beforehand, where we used things like sort of configure, manufacture, create, etc. So that just provides a bit of shorthand. Documentation must be in the preferred form for making modifications. If you're familiar with GPL licenses, that'll be familiar wording to you. So it's essentially the equivalent of source code. An intermediate form is any derivative, and I've just spotted the typo, of documentation that isn't a product. And then I'll explain a little bit more about that actually works. But for example, a bitstream would be an intermediate form. And notices is pretty broad. So the idea of a notice is something that you have to preserve from iteration to iteration. So if you take a design and you make any changes to it, then you have to put information in the notice file about how the changes have been made, what they've been. But you also have to retain all the existing notices in there. And they're things like copyright notices, trademark notices. And there's also this ability to put some exceptions in as well, which I'll sort of mention briefly. So intermediate form becomes relevant in that if you're combining multiple projects and as the result of that you produce an intermediate form, so for example a bitstream, then it means that when you release a product using that bitstream, unless you're using an exception, it means that all of the components that we used to create that intermediate form, so that bitstream, will have to be released under the CERN open hardware license. So that's strong copyleft. It's broadly equivalent to the way that GPL works in that it's designed to cover the entire project. That may be too much for some people, and the reason why that's good, which is why we introduced some exceptions. We put some provisions in there to facilitate collaborative development. So it's possible to move the designs around within a company without triggering the obligation to make those designs public. And it's also possible to be able to contract with an external organisation who's a designer, and that also won't trigger the obligations to release all of the documentation. So it allows you to create a little collaborative group where you can have internal development, and it's only when you're happy to release something to the public that the obligation to release the documentation is finally triggered. Okay, so we've got drafted a few exceptions, and one of them specifically relates to hardware description languages. And one of the issues that came up is that if you are developing HDL code, the chances are that you will have been provided with libraries by the chip company, and those libraries are likely to be on a proprietary basis. And because of what I said earlier about everything that goes into a bit stream having to be released under the CERN OHL, clearly you're not in a position to be able to release the original code for the proprietary libraries as well. So we've it allowed you to make use of an exception which has the effect of excluding those proprietary libraries from the scope of the copyleft. So it's more like a sort of weak copyleft. There's a broader form of weak copyleft which says that you can use your CERN OHL code as a library in itself, or you can merge it with other libraries, but it's only that specific code, your specific CERN code, that you will have to release the documentation to. So that's more like a sort of traditional weak copyleft. It's broader than the specific HDL copyleft exception. And we've also come up with a couple of exceptions for GPL v3 and Tapper. So the way the GPL v3 one works is that we have drafted a short additional permission. If you're familiar with GPL v3, you'll notice there's a mechanism in there that allows you to have additional terms. We've drafted a short additional term that allows you to merge code with CERN OHL code, and then we've drafted a short exception to CERN OHL that allows you to merge it with GPL v3 code. Similar thing with the Tapper open hardware license. And the effect of that is that if you make use of these exceptions, then as long as you keep, as far as possible, the bits that were originally GPL released under GPL and the bits that were CERN OHL released under CERN OHL, you don't have to release the whole lot under one specific license. You can keep it under two separate licenses for two separate components. A few other improvements that we've popped in there. We've put a termination provision in there with a cure period. So previously, if there was a violation, it terminated automatically. Now it's also terminated on notice. Now there's a cure period that allows you to, I think it's 30 days is the current figure that's in there at the moment. So if you get notified that you're in breach, then you've got 30 days to fix it. You don't automatically lose the license. We put a dispute resolution mechanism in there as well. And we're trying out a troll dissuader clause. And basically what that says is that if somebody comes at you for violation, then before anything else, they have to try and get you back into compliance. And if you get back into compliance, then they're not going to have a claim in damages against you. And this is designed to counter some of the issues that you may be familiar with in the GPL world at the moment, where certainly certain individuals, whom I'm not brave enough to name, have got a reputation for going around basically using the few lines of code that they've got in the Linux kernel as being their pension fund. This is designed to prevent that. And it's also got a few provisions in there which are just designed to increase enforceability in various different jurisdictions that I won't go into in detail. So the sort of things that we're still considering are the scope of the patent grant. This is where I need to get more representations from industry, really, to get a feel for what they're most comfortable with in terms of the breadth of the patent grant that's in there. There's a patent retaliation clause in there, but we need to look at that in greater depth. What triggers it, and if it's triggered, what do you lose? Do you lose all of the licenses that you've got, the copyright licenses and everything else, no longer allowed to use the materials at all, or do you just lose any patent licenses that you may have received? Important question is, if there's a violation, who can sue? So in the world of open source, the general assumption is that it is the copyright owners are the only people that can sue. You may be an aggrieved recipient of code, and you may only have the binary and you don't have access to the source. But the received wisdom is that there's nothing you can do about that unless you can persuade one of the copyright holders to start a claim against the upstream person who failed to provide the source code to you. Is that appropriate for open hardware? Should it be the case that anyone who has the right to access the design documentation has the ability to compel the release of that design documentation? It opens a can of worms, but that's something that needs to be discussed a little bit more. Should we be more explicit about the way in which it's necessary to place what is in effect a URL for the location of design documentation on any particular item that is distributed? And that's something we're discussing at the moment as well. So we're pretty close to having a draft that we're happy with. We're going to widen the discussion team to basically any other bodies that are interested in open hardware. We're talking to some standards organisations as well at the moment. We'd be interested in hearing from academics and research organisations, commercial organisations, and indeed anyone that's got sort of specific expertise in this area. What we're keen to come up with is a licence that works in practice. We've been coming up with a list of different use cases. We've been trying to feed those use cases into the licence and the various exceptions to see whether they work, and by and large, they are at the moment. We don't want to open it completely to public consultation because we could end up with a sort of GPL v3 process that takes years. We'd like to do something a bit more like the process that I went through recently with the Eclipse public license version 2. Which is a smaller group of people who've expressed an interest and want to get involved. But I think we're probably within about 3 months, if we do it right, of actually coming up with a license that we're happy to release to the real world. And that's it. Thank you very much indeed. Any questions, anybody?
Yeah, my question is about enforceability in practice. With software, with GPL, we have, for example, Harald Welte's work on GPL violations, and what they did was looking at strings, for example, in a binary and see if that matches messages that the code could output. In some other works, you can look at symbol tables and then say, well, that's the symbol from my library. But I'm not quite sure how this kind of stuff would look like if we are talking about mask layouts or netlists.
It's a big problem. I mean, the evidence is going to be a problem, and have been. I mean, I'm not a litigation lawyer, but I get peripherally involved in some violation claims occasionally, and you're absolutely right. Even in a case of software, it's difficult enough to establish whether a violation has occurred. From a practical perspective, that's going to be even more difficult from a hardware point of view, and whether you can actually shave the top off a chip and put it in an electron microscope and have a look at the mask itself. And I mean that's obviously a non-trivial thing to do. But luckily, I'm not a litigation lawyer, so I don't regard that as being my problem.
I think this question came up last year also, is about the standard cell libraries. Is it considered as a library? And then the GDS as your binary file, because you don't really link with the standard cell library. It's built upon it. So that's. I don't know if you.
Right. I mean, this is something that we're looking at in terms of the exceptions, and this is where I need people like you have much better understanding of the underlying technology than I do. But certainly, the basic idea is that if you take a library file and then during the compile process, or the build process, whatever you call it, it gets built into any one of the intermediate forms in the chain, then that means that you will have to release all of the source relating to that intermediate form. Okay, unless you rely on one of the exceptions. So the idea is that if you are creating code in those circumstances, you would incorporate we call it the platform module exception. And that would mean that if you're taking third-party platform modules on board, then you don't have to comply with the CERN OHL as far as those modules are concerned.
I think we have to discuss this offline. Yeah.
Sorry?
We will discuss this further offline.
Yes, okay.
Sure.
Okay. Thank you.
If I can comment, I think one of the goals was to allow designs to be to not trigger the distribution of standard cell libraries. That was one of the goals.
Yes.
Whether or not that's actually been achieved, it's not clear, but that's the goal. So.
Yeah, exactly. Julius has been sort of compiling a list of use cases, and I can't recall offhand if that's one that's on the list, but certainly it's one that we need to run the exceptions through the use cases and check to make sure that it produces the desired output.
Yeah. I mean, there are loads of things. The standard cell library is just one. Then you got the memory libraries, all sorts of other physical macros which are required to produce a chip, which you don't. Like, if you just want to have your process core, be subject to weak copyleft license, requirements, then yeah, you want something which will accept all of these other things from being distributed or included in the reciprocal part of the license.
And we want to get the blessing of the chip manufacturers as well, so that their lawyers feel comfortable that they're not releasing their libraries under the CERN OHL, that there isn't some sort of leakage going on there. So we want to try and make it corporate friendly. I'm used to dealing with corporate lawyers.
I was just wondering how it worked. What the viewpoint is with, I guess, with dual licenses. Yes. So particularly when you talked about potential for other people to sue violators.
Yes.
I guess particularly if it's dual licensed, then it wouldn't necessarily be clear to other people who had licensed it and who were using it under, licensed it independently versus those who had got the open hardware license.
Yeah, I mean that is one of the big problems, especially if you're talking about any mechanism so for example, if a recipient is given a right to exercise a right under the license, even though they're not a rights holder themselves, and if there's a dual license involved, then it's very, very difficult to determine what the relationship is between the recipient and the rights holder and multiple licenses. And because ultimately what you want a court to do is to come up with an order that says disgorge the design documentation. And if there's any argument over what needs to be disgorged, the court is going to be very uncomfortable about doing that. I mean, courts are comfortable with giving orders to stop doing things, an injunction, because either you're doing it or you're not. That doesn't need very much in the way of supervision. And they're happy to come up with orders that involve payment of money, because that's pretty straightforward as well. What courts really don't like is orders of specific performance, which basically says you must do X, Y, Z, because then that requires supervision. And if there's any dispute or if there's any question about how X, Y, Z is determined, what it is, the courts will just try to avoid that. If at all possible. It's an entirely discretionary remedy, so a court is never compelled to grant a remedy like that. And that's why we need as much clarity as possible to try and make it as easy as possible for the court to grant an order in those circumstances.
Yep.
Do you think this can be made to work with analog hardware?
It was originally designed with analog hardware.
And then, in particular, what do you do with the fact that some of your intermediate formats are going to be disliked by the foundry because they contain information which people can then use to reverse engineer the foundry process? I think that's the usual reason that foundries don't like things to be published.
Yes, I mean that's an interesting point. I think it comes down to, I mean, the main problem with whether it works or not in the analog domain is around the applicability of intellectual property in the first place. And at least when we're talking in the digital domain, we're talking about things that look like computer programs. And as a result, we can make an assumption, certainly under English law, possibly less under the law of other jurisdictions. I mean, the US is sort of fairly problematic as far as that's concerned, about whether intellectual property laws cover it or not. When you're talking about sort of purely analog designs, things like, for example, a circuit board, I'm pretty confident that would be protected as an artistic work under English law. Under US law, they tend to regard that being much more as a sort of functional item, and therefore something that doesn't attract copyright in the first place. So that does cause a problem. As far as the reverse engineering is concerned, I mean, when it's something that's in the digital domain and it's similar to software, there are automatically rights that are available certainly in the European Union, under the Software Directive, to enable you to reverse engineer things anyway. So in practice, and there's also fair use rights in the US, so in practice it's quite difficult to prevent people from reverse engineering things. The question is the extent to which those are still applicable when you move away from something that doesn't like software, and there's a lot of debate in that area. In the US, because fair use is something that is a lot more flexible than the more rigid rules that we have in the EU. I mean, in some ways, it's more likely that the courts are able to extend existing law to say that reverse engineering of physical products would be more legitimate. And also, there's a sort of more established idea in the US that physical products should be protected by patent. And of course, the whole point of patents is that they release the idea to the world in the first place. Part of the deal is that you publish the invention for everyone to look at, and the quid pro quo for that is that you're the only person that's allowed to implement it for a limited period of time. So that also sort of militates against the idea of restrictions on reverse engineering as well. But yes, interesting thought. Thank you. Okay. Anything else? Okay, great. Thanks very much, everyone.